Doctrine of Indoor Management. What is the Doctrine of Indoor Management in company law and how is it useful in the practical application of company law? The Doctrine of Indoor Management was evolved around 150 years ago. In the case of Royal British Bank versus Turkland in 1856, this doctrine was first laid. Lord Hatherley observed in his judgment, and I quote, "Outsiders are bound to know the external position of the company, but are not bound to know its indoor management." This observation became the doctrine of indoor management. According to this doctrine, any person dealing with the company need not inquire whether the internal proceedings relating to the contract are followed correctly by the company, as long as they are satisfied that the transaction is in accordance with the MOA and AOA of the company. Shareholders, for example, need not inquire whether the necessary meeting was convened and held properly or whether necessary resolution was passed properly. They are entitled to take it for granted that the company has gone through all the proceedings in a regular manner. For example, if you get a contract from a company to supply raw materials for 1 year, you need not bother if the company has passed the resolution in the meeting as per the Companies Act provisions. This is because the doctrine of indoor management protects you. The doctrine helps protect the external members from the company and states that people are entitled to presume that the internal proceedings are as per the document submitted with the Registrar of Companies or any other authority under the company law. The doctrine of indoor management evolved around 150 years ago in the context of the doctrine of constructive notice. The doctrine of constructive notice and the doctrine of indoor management are both interrelated. The doctrine of indoor management is in fact opposed to the role of doctrine of constructive notice. We will explore that in another video. Whereas the doctrine of constructive notice protects the company against the outsiders, in the doctrine of indoor management protects outsiders against the actions of the company. This doctrine is also a possible safeguard against the possibility of abusing the doctrine of constructive notice. There are some bases for the doctrine of indoor management. First thing is, what happens internal to a company is not a matter of public knowledge. An outsider can only presume that the intentions of a company are true, but not know the information or he or she is privy to. And the second important basis for us to understand is that if not for the doctrine of indoor management, the company could escape creditors by denying the authority of officials to act on their behalf. There are some exceptions to this rule. This rule doesn't apply in every case. For instance, a legal remedy when you file a case against a company cannot be claimed on the doctrine of indoor management if the circumstances in the case suggest that the outsider had a knowledge of the irregularities in the company and still he pursued the decision with the company and went ahead with the contract. Another exception is when the outsider did not refer the MOA and AOA. That was his duty. He didn't do it. So in such case also, you cannot take shelter and protection of the doctrine of indoor management. Another exception is forgery. If there's been a forgery, let us say a forgery in the signature, that will not protect you and outsiders are liable regardless of the doctrine of indoor management in case of a forgery. Well, this was a short summary of the doctrine of indoor management. To know how it is connected to the doctrine of constructive notice, check out our video on doctrine of constructive notice. The link is there in the description below. To get more videos on law, please subscribe to our channel and do leave a comment. And of course, if you want any specific videos on topics which you like, please feel free to ask.